name is Naomi Goodnow. I am the Dean of Students here, and I want to welcome you to our Law Review Symposium. You can see the title up there, Regulating Tech, Present Challenges and Possible Solutions. I am so excited to have all of you here today, so thank you so much for coming out on this very important, timely topic. This is Pepperdine Law Review's Symposium 46th volume, and so this has been happening for a while. This symposium today is put on in partnership with the Federalist Society's Regulatory Transparency Project. We have a great day lined up for you. I was actually kind of curious who was in the audience, and so if you are a lawyer, could you raise your hand? Fantastic. Lawyers from the LA area. A couple of lawyers outside of the LA area. All right, well, thank you for traveling. That's fantastic. We also have some students in here. How many students do we have in here? Fantastic. And how many professors do we have in here? I know there's some being on panels today, so we've got a couple of them scattered throughout. I think the makeup of the audience is actually exactly why this is such a wonderful topic. The topic is to bring together practitioners and scholars, and our soon-to-be practitioners and scholars, our students, to talk about these very important challenges and excitements. I was thinking this morning as I was driving in what to talk about. I'm clearly not the expert on this, but I'm in a room full of experts. So the only thing I can say is I have a 5-year-old daughter who literally learned how to get into my cell phone and open apps before she was talking. And so obviously, for any Star Trek fans out there, this is the new frontier. And it's very exciting to be able to have this symposium today. Obviously, the private actors are faced with conflicting, ambiguous, and maybe absent regulatory frameworks. And then on the other hand, we have our policymakers, our legislators, who are trying to figure it out and enforce some sensible, effective regulatory schemes. And so I believe that those are some of the topics we are going to try to tackle today. And as you can see by the wonderful panelists that were put together in our agenda today, we are going to be tackling all of those problems from a variety of different perspectives. Because we have so many perspectives in the room, slight disclaimer, right? Any comments that panelists make do not necessarily reflect the views of Pepperdine or of the Transparency Project. So I'm hoping we have some fun debate today on that. So I do want to thank one particular person who helped to really put that together. Ashley Kubecki is right over here. Can you please stand up? So Ashley is our Law Review Symposium editor who is solely responsible, with obviously some help from the Law Review and some professors here, putting this together. And so I think you did a great job, Ashley. I know you're going to be heading to DC, is that right? After she graduates, clerking and working at a large firm there. So I'm very impressed, and I'm glad DC is going to be having you join their ranks. I get the wonderful job of introducing Donald Rosenberg, who is going to be delivering the open remarks. And so Mr. Rosenberg will come up in just a moment. A brief introduction. He is the Executive Vice President, General Counsel, and Corporate Secretary of Qualcomm Incorporated. As you know, Qualcomm is a leading telecommunications company that both designs and markets wireless products and services. He is involved as their Chief Legal Officer and responsible for overseeing Qualcomm's worldwide legal efforts, including litigation, intellectual property, and corporate matters. I'm telling you, Mr. Rosenberg, that's pretty amazing, because usually you pick one of those 3 things as a career. You managed to do them all, and you're doing them all right now. Prior to joining Qualcomm, Mr. Rosenberg was the Senior Vice President, General Counsel, and Corporate Secretary of Apple. And not to leave IBM out, he was also their Senior Vice President and General Counsel prior to working at Apple. In addition to all of his practical experience that he'll bring today, he is also involved on the academic side. He's a member of the International Advisory Board at the University of California, San Diego, Global Policy and Strategy. He's a member of the China Leadership Board of the 21st Century China Center, which I think sounds really fascinating. He served as an adjunct professor at Pace School of Law, where he's taught courses both in intellectual property and antitrust. Mr. Rosenberg, thank you so much for joining us today.
Thank you for that introduction, and thank you for inviting me here in particular. I want to thank Dean Reuter, who originally talked to me about it. It was a pleasure to come here, frankly, when I saw the topic, I want to get into it. I will say in advance, I guess, various disclaimers. You probably know, although you may not, that Qualcomm has been involved in a number of matters around the world for the last several years. We still have many, many matters pending, including at regulatory agencies, but also private litigation. And so I've tried to plan my remarks so that I don't touch on anything that is too sensitive for me to talk about. So if you're looking for more insight than I'm giving you, that's the reason. So this forum, as I said, I was going to say could not be more timely, but frankly, I'm very happy you're doing it. I wish others had done it sooner, or you had done it sooner, but that's not a criticism. At least you're doing it. This has been going on for quite some time, and I want to give you a little bit of background. I spend a lot of my time. I'm also the head of government affairs in Qualcomm, so I spend a lot of my time with legislators and policymakers, both in the United States and in multiple places abroad. And quite often, as part of that process, answering one of the questions that you've framed today is critical. How can government regulators and legislators avoid stifling opportunity, function more efficiently, and enact and enforce sensible and effective regulatory schemes? The answer is that regulators must keep in mind that legislation may or may not serve to improve the allocation of resources in a particular industry, compared to the outcome in the absence of regulation. Successful identification of a market imperfection is a necessary but not sufficient condition to justify regulation on economic grounds. Once a potential market imperfection has been identified, the proposed regulatory solution must itself survive a rigorous economic cost-based analysis, one that factors in the potential for imperfect regulation and unintended consequences, as well as the effect of alternative solutions that can develop without government intervention. Evaluating the costs and benefits of regulatory alternatives requires a solid understanding of market imperfections and the particular market imperfection that supposedly is being solved, as well as mechanisms used by the market participants themselves to have mitigated the effects of those imperfections. Unfortunately, too often, governments seek to impose regulations in the absence of evidence of market failure. We have seen this where regulators with a solution are searching for a problem. But we have also seen this where their proposed solution doesn't pass basic cost-benefit analysis. The proposed solution would cause, in effect, more harm than good. There is something else that regulators need to keep in mind. When it comes to specific sectors like 5G, which I'll get to in a little while, and something called the Internet of Things, subjects that are near and dear to my company's heart, which I'll talk a little bit more about later. One of the key dangers is regulatory capture. Regulatory capture is a form of government failure. When a regulatory agency created to act in the public interest instead, wittingly or unwittingly, advances the commercial or political concerns of special interest groups or specific companies. The key danger here is that certain regulations that shift economic rents from the group of companies, one group of companies to another, may have far-reaching implications beyond merely changing how the slices of the pie are divided. They may, in fact, have significant value effects resulting in shrinking that pie for all. So, in addition to following the economic framework I've just set forth, what are some additional safeguards when it comes to regulation and enforcement? And I'm going to talk about testing theory and empirical data. As someone who has worked at the intersection of law and economics for 3 innovative companies, as you've heard, I am, as I said, quite gratified that these difficult questions are being asked at symposia like this. Academic discussions are invaluable, but regulation must be based on real-world data, not theory. And enforcement must be based on properly applying the law to the facts of a particular case, rather than theoretical speculation of what could be or what might have been. Yet all too often, governments base regulation and enforcement on theory alone. But theories have testable implications. Did the activity at issue actually cause higher prices? Did it reduce innovation? Government officials must test their theories using the empirical evidence available. And there is plenty of empirical evidence widely available, just digging for it, not too deeply. In addition, all regulation and enforcement of that regulation must be framed, carried out, and solidly based in the rule of law. The rule of law. This is a deceptively simple phrase, and I certainly hear it very often in all kinds of places. It's the all-important ingredient for an economy that wishes to nurture and promote innovation. When decisions are made in the private sector, in essence, when decisions about risks being taken, money invested at one place, one direction or another, what country to perhaps invest in and establish a position in, when jobs are created or not, the certainty of a given legal environment is among the most important factors. We invest with the goal of recouping and multiplying that investment. We may gamble on the strength of our ideas and plans, which Qualcomm does all the time. Our research into the Gs, and I'll get to that in a minute, often takes close to 10 years of research and development and investment. So we can gamble, as we do, on the strength of those ideas and how much the marketplace will like them. My engineering colleagues often boast about what the founders used to say too, which is that we're going to invent, but we'll probably not think of all the uses to which our inventions will be put once they're out in the marketplace. And that has proven true over and over and over again. I can give you example after example of things that are ubiquitous, things that you take for granted, that but for the inventions of my company and others just would not exist. One example that just popped to mind is Uber. You can look at the process by which you hire an Uber car. Every step of the way has an element of something that Qualcomm invented in that process. So those are the risks you take. But the certainty of a given legal environment is, as I said, among the most important factors. We don't want to gamble on the stability of the rule of law. I'll give you an example that I briefly describe now and then come back to because it is in so many headlines, and I've referred to it a few times, and it's 5G. And you may have heard something about 5G, unless you've been living under a rock someplace or in law school. And most people will tell you a lot about 5G and know nothing about it. It's amazing to me. I spend a lot of time, and I've spent a lot of time over the last several months in Washington, D.C., pretty much weekly. And I've got a lot of interest in 5G there, and which I'm very pleased about. But describing it, explaining it, enlightening people as to what 5G means and what it will do is an interesting task. It's good because they know there's something important there. What I have to do is fill in the blanks. I'm going to give you a very quick primer, very quick, so don't expect much. So let's go back. The first generation of mobile communications, 1G, had brick-sized phones. Most of you in this room don't remember that. I do. And you had a handful of users, literally. I mean, just a few users around the world. And these things were expensive. They were unreliable. All they did was analog voice communication, and they did that really poorly. Your calls would be dropped often. The brick would run out of power. There were a lot of problems with those. But it was an enormous innovation. The second generation introduced digital voice service that was less likely to have the problems I described, like dropping calls. And it was available to many more people and ultimately cheaper to use. So typical advancement of technology. 3G ushered in the mobile internet, mobile computing, and the proliferation of apps, application programs that we all know about. 4G, which is often called LTE, and I'll give you something that you could use at the next cocktail party. What does LTE stand for? Long-term evolution. Don't ask me why, but those are the words. It was made possible. I think I actually could probably tell you a little bit as to why, but I won't bother. That made possible what we have come to expect of mobile broadband: streaming video, audio, instantaneous ride-hailing. I forgot I had put that in there from Uber. The explosion of social media. Just to step out of the framework here, Qualcomm literally was the company that provided the foundation for all that we appreciate today from the communication device we hold in our hand. You may have heard of something called CDMA. It's another one I'll give you just occurred to me, the acronym, Code Division Multiple Access. I'm not an engineer, but I play one in the, but that was an incredible breakthrough. It was a technology that actually had existed and frankly had been used to some extent during World War II by the US. But the small number of founders, 7 founders at Qualcomm, and I've talked to Irwin Jacobs, who came up with the idea several times about it, decided that they could adapt this technology to cell phone mobile communications. And you got to remember, this was in the 1980s. It was an incredible step. In fact, Irwin likes to point to a Stanford physics professor at the time who, when he heard about it, said, it defies the laws of physics. It can't happen. But all that ultimately led to what we have today, the ability to have this kind of massive data flowing back and forth instantaneously, that, as I say, we underappreciate because it just seems natural. And most people think that there's magic in the device. There is, but it's the technology that's underlying it, not the pretty device itself or the ease with which you can manipulate things on it. Okay, enough for my... So, as I said, we take all this connectivity for granted. But the engineering behind the evolutions of these Gs, these generations, really, as I said, would have seemed impossible just 20 years ago. 5G can be appreciated when you think about a world in which not just people, but all things are connected. And this is the connection between 5G and IoT, or Internet of Things, that you hear all the time. Cars will be connected to other cars and to the road, and frankly to everything around them. Why? You have to have sensors in cars if they're going to have autonomous driving, because one car has to know that another one is coming around the corner, or that someone's about to step into the street, or to distinguish between that person and a plastic bag that's in front of the car. These are all sensors, and they need to communicate with one another. 5G is bringing that level of communication capability, and instantaneous is something the engineers called latency, which is the time between when a signal is sent and when it's received. You don't notice it. Your ear doesn't even detect it when you're talking to people, and your eye when you're looking at it. But there is a latency factor in all of this. And one of the things that we work on constantly is reducing that latency factor. Once we get to 5G, there can be almost no latency, because as I just described, you have connectivity of cars and in life and death situations. You have doctors who will be connected to your personal medical devices. They can't wait a few seconds for a response when something is critical. There are augmented reality concepts that we haven't thought about today, but some of which are obvious. Augmented reality is going to be used pretty ubiquitously, actually. It's going to help people do simple things like shop and learn. It's going to help you explore the world around you or the world far away from you. It's a phenomenal process that's only just begun. You hear augmented reality, you hear virtual reality. These are things that are going to happen. They're all going to happen because of 5G. The other thing about 5G, which probably goes without saying, but I should say it, is it's going to speed up, not just the latency issue, it's going to speed up the communication. It's going to increase the ability to have massive amounts of data flowing back and forth into your hands. And that couldn't be done without 5G. And it's going to do it using less power and more efficiently. And that's critical to what 5G is all about. The billions of connections, literally billions of connections that 5G is going to facilitate, and making those connections, very importantly, secure as well as instantaneous, is what's critical here. In addition to impacting all the industries I described, it's going to impact our industrial makeup. Organizations from auto manufacturers, manufacturing distribution, emergency services are all going to take advantage of the capabilities of 5G. And they're going to do so by creating new private networks in many situations. And the reason you can do that is because they're going to be smaller baseband units. I don't want to get into detail, but you know about antennas, you know about all the communications that go on. Now we're going to have more dense, smaller communication vehicles between you and the network. That's all going to happen. The privacy point, the security point, very critical for 5G, and therefore very critical for industries who are going to use it. This is another critical factor that most people don't appreciate. 5G that's going to be introduced this year, there will be 5G capability introduced this year, thanks to us having worked with pretty much every carrier around the world. But that's only the beginning of 5G. 5G is going to roll out over the next several years, maybe 5 years or more. And there are going to be applications and new technological advances in 5G that are going to bring it, as I said, doing things that we're not even anticipating today. And it's purposely designed so, as I said, these industries, these other industries, up until now, mobile communications has basically been you and your phone. Now we have all these things talking to one another. That's mobile communications, that's connectivity. And all of them are going to take advantage of the cellular connectivity that I talked about. And it wouldn't have been possible before. And the scaling that is going to be allowed and facilitated by 5G as it expands is going to be fairly phenomenal. So why do I bring 5G up and talk so much about it in the context of government regulators and legislators, and why they should avoid stifling opportunity and innovation? These generational changes that I've talked about in mobile communications don't just appear overnight. They didn't just appear overnight. They require significant efforts in research and development, as I've said before, and the resources necessary to support those efforts. We're talking about billions and billions of dollars in investment. Each G represents the solving of tens of thousands, I'm not exaggerating, tens of thousands of technical and engineering problems. And it requires international cooperation at some level in developing what are basically telecom standards. This requires participation and consensus building among a disparate group of national, commercial, and scientific parties, all working together for the common good. And I'll get back to both the rule of law, well, I'll talk about standards right now. Like 3G and 4G, 5G is the responsibility of the standard setting organization known as 3GPP. Won't bother learning what that is. It's a handful of companies, and it literally is today a handful of companies only, that are spending the resources inventing technologies. They come together with many, many other companies who will develop products that implement those technologies. Think about the process for a moment. Engineers from rival inventing companies, rival product makers, rival wireless network operators, all from different countries and continents, discussing, testing, striving to agree upon tens of thousands of different technical solutions that ultimately make a standard like 5G. They judge each technical solution using a merit-based consensus-building approach. This process has been at the foundation of a technological revolution that spawned myriad new industries and millions of new jobs and well over $1 trillion in economic growth up until now. It's the fusion, and almost the perfect fusion of self-interest, nothing wrong with that, with the recognition that some problems are best solved by working together. And just stating the obvious, I'm sure, but there can't be a better example of why a standard is required than in mobile connectivity. If you want to make sure you're able to talk to somebody in Japan just as easily as you're talking to somebody in San Diego right now, you need to have certain agreements about the standards process. If you want to have multiple network operators in multiple countries around the world, they have to agree on certain standards. You can't have one with a private standard here and another here and trying to talk together. So from its inception, of course, standards have been a critical aspect of mobile communications. This model of international and intercorporate cooperation is responsible for the fastest growing and most widely adopted technology in history. As I mentioned earlier, we take it for granted that every few months there will be a new smartphone model from a different company, or in the US, Apple or Samsung. That's basically it. By the way, there are basically 3 phone providers in the US at this point. It's Apple, Samsung, and LG, 2 Korean companies, and Apple. And they'll have these new devices will have new functions, new capabilities, and you'll immediately consider them indispensable, even though they weren't imaginable a few days ago, as will I. And they're all for a price that steadily declines in relation to the value of these new technologies, thanks in part to thriving competition and the ease of entry of new handset makers into this market. My primary example of ease of entry for anybody who's willing to listen is a company in Cupertino called Apple. We may not recall that just a little over 10 years ago, 2007, Apple decided to enter the phone business, the cellular phone business. They did that in the face of competition from the likes of Nokia, who, if any of you spent any time in Europe in the old days, knew that phones were called Nokias back then. That's how powerful. A Motorola, major provider of technology. BlackBerry. And what's interesting as I name all of those, and I tell you, and those who remember can recall the power that those companies had in 2007, 2008. Some of you who weren't that cognizant back then don't even know why I'm talking about them. Because as I often say, they've been relegated to the dustbin of history. Why? Because Apple has pretty much taken over. Apple, Samsung, as I said, LG, and a whole host of Chinese device makers. But I use Apple as the example of ease of entry, which is the competition concept that regulators think a lot about. And it was easy for them to enter, and I'm not saying I happen to have been there in 2007. I'm not saying anything that's inappropriate at this point. But it was Apple who entered the market in 2007, and now, a few months ago, reached the $1 trillion mark in market cap. It's a pretty extraordinary development, and it certainly says a lot, in my opinion, about the competitive nature of this industry. So back to the standard process. The inventing companies that are involved agree that if their patented technology is adopted into the standard, so companies like Qualcomm, Huawei, Ericsson, Samsung, who are doing a lot of research and coming up with what they think is the best technological solution. I apologize, I'm going over time, but I'll try to speed up. Put on my New York speed, as I told somebody. Try to figure out how I can. So the inventing companies, the few inventing companies, offer their technology, but they do so at a price. If they have technology that they have intellectual property on, like patents, in our case, we have something in the range of 130,000 issued and applied for patents in our portfolio. But if you have patents on the standard essential patent, that is the standard technology, then in contributing it, you give up certain rights. You give up in the first instance the fundamental right of a patent, at least in the first instance, and the fundamental right of a patent is the right to exclude. If I have a patent, I can keep you out of my, think about it as a fenced-in real property, I can keep you out of that property for 20 years, let's say. Or I can let you in on terms that I choose to let you in. But in the first instance, I say, look, I'm going to agree to license, let you in, certain people in, anybody who is practicing that standard, that full standard. That's the price I'd pay for having you accept my technology, which, by the way, I invested billions in and spent maybe up to 10 years inventing. But I give it. All I want is a return. And I don't even have the stick that I would normally have in the first instance to say, and if you don't pay me, I'm coming after you with an infringement action, because in the first instance, I have to offer you a license. I have to say, here's a license. And it's got to be on fair, reasonable, and non-discriminatory terms. F-R-A-N-D. That's the European version. There's the US version. We don't think of fair. We just go reasonable and non-discriminatory. But essentially, it's fair, reasonable, and non-discriminatory, which means there's some kind of cap. Not defined necessarily, but as we have often argued, as I say all the time, it is defined. It's defined by market dynamics, and it gets defined in that way, which is a point I'll make as to why regulators probably step aside. But that fair, reasonable, and non-discriminatory license is what we have to offer. And anyone who says, I want to build a phone, and I need access to your intellectual property. Now, access, of course, is an interesting concept. They all have access to it. One of the things people forget, sorry, I'm going off a little bit here, but one of the things people forget about patents is it's a social bargain, a social contract. You often think, people generally sometimes think that, gee, you're just handed a patent by the government. That's a monopoly, you know? You shouldn't be able to abuse that thing that the government gave you. Well, the government didn't give you the patent. You applied for the patent. You spent 3 or 4 years or more convincing patent examiners that this was in fact new, novel, non-obvious, all the elements of what's required, really tough stuff to get over to have a patent issued to you. And you also made enormous contributions in that process. You had to file specifications that describe in intricate detail your technology and your invention, and you had to define very clearly the parameters of that invention, so-called claims. You can't just say, here's new technology and I'm going to take it all. I'm going to narrowly define what claims I'm going to make based on this new technology. That is now in the public domain. Anybody can read it, anybody can access it, and anybody can design to it. So unlike real property or personal property, I can't stop you from taking my property physically. You take it because you go read about it, and then you can go implement it. The only thing I have is the rule of law. But even where the rule of law is strong, take the United States, it takes time, it takes money, and the dynamic of litigation or dispute resolution is something that often companies just can't deal with on a long-term basis. Most of the wireless evolution that I've talked about, for most of that period of time, regulators pretty much respected the FRAND agreements between standards organizations and the inventing companies. And the resulting competition and benefits to consumers would seem to make wireless telecommunications, in my mind, the epitome of what balanced regulation can make possible. This regulation, though, was really designed by the participants within the standards body, and the regulators pretty much had a hands-off approach, because, as I said, it's multiple parties at every level of the industrial chain agreeing by consensus to reach that. So it sounded like a good process. And now it's at risk, and it has been at risk, that balance, for some time. There have been recent enforcement actions all around the world that have put a thumb on the scale in favor of one group of participants in the industry, what we call the technology implementers. You can assume I'm talking about device makers, the phone makers. And they benefit from the use, as I said, of the fundamental technology that we've innovated. And that thumb on the scale provides an advantage, a benefit over those who have created these fundamental technologies that drive the entire 5G, will drive the entire 5G ecosystem. And among the many dangers of such an approach is the far-reaching implications, beyond merely shifting rents or value from one company to another, which is really what this is about. But it can instead significantly harm innovation beyond that and consumers. This is because this 5G and IoT chain, value chain that I was talking about is complex, it's multilateral. It's a vertical chain with many participants. You've got 5G and IoT layers of technology, which is what we're involved in. There's the very core communication layers that I'm talking about. And then you've got the fundamental building blocks for the entire supply chain, data layers, application layers, and process layers. Given that the companies participating in each of these layers are complementary, there are strong interdependencies among them, such that the value generated by the entire IoT chain depends on the success of companies at each individual layer. The conditions for success, and therefore, are very clear. First, companies at all layers must have the ability and the incentive to invest, and they must choose to then actually invest. Secondly, each layer, the most efficient technologies at each layer must be selected. And in addition, the overall price or total cost of ownership needs to be sufficiently compelling for a consumer. The solution to facilitating this nascent IoT ecosystem is, in my opinion, threefold. Enforcers and courts should appreciate that certain companies do not care about consumer welfare or growing the pie, and they only seek to take more slices of the pie for themselves. They also, regulators should recognize that fundamental technology innovators like Qualcomm and a few others have to be incentivized to invest in future research and development that will grow the overall pie. And the focus of any scrutiny by regulators should be on performance, real-world evidence of the amount of innovation and value created by companies at each layer, as opposed to simply counting the number of players at each level. This leads back to the regulatory scheme of this conference and my focus on the rule of law. Specifically, global antitrust and competition regulation is what I want to focus on briefly. Today, there are more than 130 competition agencies around the world, many, if not most of them, operating without the benefit of a mature legal environment. While most major jurisdictions agree, at least in principle, that the goal of antitrust is to promote consumer welfare, in many foreign jurisdictions, decisions are in fact driven by industrial policy and other non-competition factors. Compounding the problem, there is little substantive convergence on legal procedural norms, at least in practice. There are no international safeguards in place to prevent local antitrust from being used as an industrial policy tool to protect domestic champions or to prevent competition regulators from acting when influential or powerful companies simply don't like how much they are paying, for example, for intellectual property rights. There is nothing to prevent multinationals in this environment from weaponizing antitrust law to stir up regulators against their competitors or suppliers. In recent years, we've seen a very troubling trend overseas of investigations of large foreign companies, enforcement actions that fail to meet the requirements of basic due process, and that raise concerns about the impartiality and accuracy of the decision-making process. We have reason to be concerned that the lack of respect for due process could result in arbitrary decisions not based on the rule of law and sound economic evidence. These concerns are particularly serious in those jurisdictions in which domestic entities that have economic strength and strategic importance may benefit from an outcome of an investigation. And with antitrust authorities often left to define the limits of their own power, I'm not sure any jurisdiction is immune to these problems. So how should lawmakers and regulators who seek the right balance put in place the needed checks and balances? What, in fact, should these checks and balances be? Originally, in jurisdictions with well-developed, in jurisdictions with well-developed rule of laws, optimally, the judiciary plays this role, or at least should play this role. But there's no global system, leaving the private sector to deal with a patchwork approach, one jurisdiction at a time. Years ago, I called this the lowest common denominator. If you're a global company trying to figure out how to do business effectively and not subject yourself to competition problems, you have to figure out who the most aggressive enforcer agency is in the world, and then adapt to that enforcer, and then you have to do that around the world because you can't have different policies in different countries. So we can hope for things like the OECD, the Organization of Economic Cooperation, or ICN, the International Competition Network, who gather regularly and try to nudge countries to accept and stick to best practices and things like due process. But it hasn't worked well so far. I'm not saying give up on it, but it just hasn't worked well. And the world at the moment is frankly at somewhat of a nadir when it comes to international cooperation. So we can hope that other elements of a given government, like those who worry about innovation, not competition, those who worry about trade and economic growth, not competition, will exert appropriate pressure on regulators to keep regulation and enforcement on a level playing field, at least hope in the context of market-based economies anyway. And by this I mean with the least amount of uncertainty of the kind I mentioned earlier. Standards essential patents like those I have described now, probably in too much detail, are a good example, case in point. There is a theory most famously posited in 2007, an interesting year, that standards essential patents pose a competition threat because the invention companies that contributed those technologies to a standard and therefore own standard essential patents could hold up product makers, demanding exorbitant royalties. There's much I could say, unfortunately, about this, and I'm so way over time, I apologize. But I won't get into the detail. But for now, it's enough, I think, to remind you of 2 points I made earlier. To have technologies included in a standard, invention companies must agree to license at the terms I described to all device makers who want a license. And in the 12 years since this theory was put forth, and even before that, but certainly in those 12 years, evidence from the smartphone space, and that includes both standards and patents is quite to the contrary of what the holdup theory would claim. Output has grown exponentially. Competition in semiconductors is thriving. Wireless service providers have dropped prices have dropped relative to overall consumer price index. Prices in SEP-reliant industries in the United States have declined faster than prices in non-standard essential patent-intensive industries. In other words, this is an overall thriving industry which cautions great care about disrupting the carefully balanced FRAND ecosystem that I described. Almost done. Despite the evidence, the theory has nonetheless stuck around, this theory of holdup, even in some quarters of the United States government. It's why some in those regulators have adopted an approach that treats standards essential patents as a potential competition problem. To that point, the serious practitioners of innovation economics, who rely on empirical data rather than theory, are very worried that standard essential patents could very much be weakened. I think they already have been to some extent. And this, of course, in turn would imperil the standards process, which I said was so essential. Since invention companies will contribute their technologies to a standard like 5G only if they can recoup the billions of dollars and years spent in R&D. Without strong intellectual property protection for standardized technology, the continuing development of 5G and even 6G beyond that would be significantly diminished. Now, fortunately, there are others in the US government who have recognized this risk and have stepped in to the debate, specifically, most recently, Macon Delrahim, Assistant Attorney General at the Justice Department for the Antitrust Division. And in a series of speeches, Macon has suggested antitrust enforcers have, in his words, strayed too far, undermining incentives for IP creators who are entitled to an appropriate reward for developing breakthrough technologies. That was a quote. He argues that the application of antitrust law without empirical evidence is a threat to innovation, consumers, and businesses. And in what I consider to be a model of enforcement and humility, he has forcefully made the case for why common law and contracts law are up to resolving any problems in this area without regulatory intervention. He goes on to say, and I'll exclude some of Macon's quotes here, but I commend you. He's given about 6 speeches now in various functions, and I commend you to look them up and use your connectivity to bring them down and read them. Regulators can avoid stifling opportunity and innovation while enacting and enforcing sensible and effective regulatory regimes. Refrain from imposing economic regulation absent evidence that there's an identifiable market failure and the proposed regulatory solution survives a rigorous economic cost-based benefit analysis. In other words, stick to the same philosophy that doctors do. First rule, do no harm. Or as others have said, if it's not broken, don't try to fix it. Refrain from regulation and enforcement actions based upon theory alone, and instead ensure that any theoretical harms are backed by empirical evidence. That's the key message that I'd like to convey to regulators as they proceed in this very endangered environment. Thank you, and I apologize for having gone so far over. I'm apparently fairly passionate about this subject.
Thank you, Mr. Rosenberg, for your remarks. As someone who's really interested in regulation of the augmented reality sphere, and as someone who was the proud owner in 2007 of a BlackBerry Pearl, I really appreciated your remarks. Right now, I'd like to invite the panelists and moderator for our first panel on the General Data Protection Regime and the California Consumer Privacy Act to join us on stage.
Hi, good morning, everybody. My name is Anna Shaw. I am the head of the West Coast offices of ZwillGen. We are a law firm that helps companies navigate legal issues with doing business online. So a lot of our work is on privacy and data security, which is essentially what we're going to talk about here today. The two topics being the GDPR, General Data Protection Regulation in the EU, and the forthcoming California law, the California Consumer Privacy Act, otherwise known as the CCPA. So we have 4 panelists here. To my immediate left is Tom Hazlett. He is a professor of economics at Clemson University. He previously taught at George Mason, UC Davis, and the Wharton School, and he was chief economist of the FCC. He is a noted expert in regulatory economics and information markets, with research appearing in academic forums such as the Journal of Law and Economics, the University of Pennsylvania Law Review, and the Columbia Law Review. He's also written for a number of periodicals, including the Wall Street Journal, The Economist, Slate, and the New York Times. And his most recent book was featured as one of the top tech books of the year at CES 2018. And to his left is Matthew Heiman. He is a senior fellow and associate director for global security at the National Security Institute at the George Mason Law School. He is the chairman of the Cyber and Privacy Working Group of the Regulatory Transparency Project, and he is the chairman of the International and National Security Law Executive Committee Practice Group of the Federalist Society. He previously held roles as the vice president, corporate secretary, and AGC at Johnson Controls. He was a lawyer at the National Security Division of the DOJ, and he was a trial lawyer with the law firm of McGuire Woods. He has a BA and a JD from Indiana University, and he's a member of the International Institute for Strategic Studies. And then to his left is Gus Hurwitz. He's a law professor at the University of Nebraska College of Law, where he co-directs the Space, Cyber, and Telecom Law program. His work focuses on the regulation of technology, in particular in telecom and emerging technology industries, and he has appeared in many law reviews and other journals. He's been cited by courts, Congress, and federal regulatory agencies, and he has degrees in both law and economics, along with a background in computer science. And then finally, we have Chris Riley at the end. He's the director of public policy at Mozilla. He works to advance the open internet through public policy analysis and advocacy, strategic planning, coalition building, and community engagement. He manages the global Mozilla public policy team and its active engagements in Washington and around the world. Before Mozilla, Chris was a program manager at the US Department of State on Internet Freedom. He was a policy counsel with the nonprofit public interest organization, Free Press, and he was an attorney advisor at the FCC. Chris holds a PhD in computer science from Johns Hopkins and a JD from Yale Law School. He's published scholarships on topics including innovation policy, cognitive framing, graph drawing, and distributed load balancing. So I'm gonna ask all of the panelists to give kind of a high-level overview on thoughts, but before I do that, I just want to give a brief summary of what the GDPR and the CCPA are. So I'm sure all of you have some sense as to what the GDPR is, because I'm sure last year you were bombarded with inbox messages about, we've updated our privacy policy. So basically what the GDPR is, it became effective last May, and it's a pretty landmark piece of legislation that effectively applies to all personal data of EU residents. And personal data is defined very broadly in the EU to be anything that relates to an identified or an identifiable individual. So typically in the US, when we think of personal data, we think of a name, something specific to your address, your email address. The EU takes a much broader view. So like an IP address would be considered personal data because it's identifiable to someone. Your device identifier on your phone would be similar. So one key difference between how Europeans see personal data versus the US is that in the US, you can typically do whatever you want with personal data as long as there's not a law that says you can't do it, or there's a law that says this is how you have to do it. In the EU, you can't collect that, store it, or process it in any way unless you have a legal basis to do so. So that's a huge difference between the US. So the CCPA, which is the California law that's going into effect in 2020, it's similar to the GDPR, but is different in a number of material respects. So CCPA's focus is not so much on you have to have a legal basis, again, because in the US you don't need to have that. It's more on giving consumers notice as to what you're collecting and also control over what you collect about them. So one of the main things about the CCPA is that it requires companies that sell personal data. Again, no one really knows what sell means, but those who sell personal data of California consumers have to, for example, include a conspicuous opt-out link and basically allow consumers to opt out of that sale. Both the GDPR and CCPA also afford individuals with these individual rights to be able to access their data and in some instances delete data that companies have about them. And both statutes carry some type of a private right of action, and they have fines for violation. So if each of the panelists could just give some high-level remarks on these, that would be great. Tom?
Thanks very much. Thanks for having me. As has been said, it's a great topic, a great time, a great place to have this. And speaking of tech and the latest thing, I'm delighted to be at the Malibu Beach Inn, where I was recently, in the last few hours, introduced to the concept of a smart bathroom. And so this was highly impressive, slightly creepy, a little unnerving, but I'm not going to go into detail here, but it does have to do with motion detectors and heated seating. So.
This was not on the agenda, so I'm not really sure how to ask
This sounds like a privacy topic.
So yes, we can actually spend our time on what people want to talk about now or go back to the agenda. Okay, so yeah, recently I saw Senator Wyden from Oregon introducing legislation on the issue of privacy, and the argument was that Facebook can't be trusted to protect users' data on its own. It's time for Congress to step in, and there's a number of features in the legislation, more resources for the Federal Trade Commission to monitor certain privacy breaches, increasing potential fines on social media platforms like Facebook and Google, up to 4% of annual revenues. And there's a lot in there. Some of it I think is arguably helpful. And I also think the basic approach is extremely dangerous, extremely problematic. The idea that Facebook is being trusted to do this on its own now, and that doesn't work. Congress will hold their feet to the fire, puts us almost automatically on the wrong path. We have to see a lot more of the problem and see it much more clear-headed than that. First of all, since the Cambridge Analytica scandal, you can call it a breach. Facebook originally tried to deny it was a breach. March of 2018, since that time, while Congress has been putting together legislation and holding hearings, the stock markets have been busy figuring out solutions of their own. Facebook is down about $40 billion in capital value. That's of February 1st and includes the very positive January quarterly earnings report that increased Facebook's capital value. And in fact, Facebook was down over $100 billion in capital value earlier in that period. That is to say that, and this is market adjusted and looks to be associated with the privacy problems of Facebook. Many changes have been made, getting the right mix, the optimal configuration of privacy rights, user rights, and so forth. Very, very difficult. That's why we're here talking about it. It's very problematic to have accounts that consumers are going to be protected by rules that do not allow them to trade their privacy or information for free services, because we know across a wide range of behavior that's what consumers want to do. By the way, a recent laboratory experiment asked human subjects in experiments, how much would we have to pay you to get you off Facebook for a week? And so this was, sort of a delisting of Facebook accounts that was enforced by the experiment. And it turns out that on average, the bids that came in constituted a $1,000 a year payment, on average $1,000 a year payment to take Facebook users off Facebook. The value that's being generated by Facebook for shareholders is a small fraction of the value that's being created for users. Now, better disclosure, better information, better consumer adjustments can certainly be thought about, maybe improvements for things like government monitoring, posting, better transparency and information, even rules for additional causes of action and litigation, obviously on the table. But in trusting government to step in, we have to remember the other side of this. In 2014, 2015, perhaps the most serious privacy breach in American history took place. And that's when about 22 million personal records kept by the United States Office of Personnel Management on Department of Interior computers were hacked with what U.S. intelligence authorities think were Chinese government bots, which actually lurked around for about a year because they found so little security. And by the way, these 22 million personal records were not encrypted by the United States government. And the bots sort of moved around for a year, finding the lay of the land. Then after 1 year, began encrypting the US files. This is the Chinese hacker encrypting US files. It wanted to be secretive in withdrawing the information and not allowing US security forces, if they were monitoring the situation, to actually see what the Chinese were doing. They took these records. Of this treasure chest, 4 million Americans working for the federal government or previous federal government workers had their medical histories, their entire employment histories, their social security numbers, raft of information about family affairs and so forth, taken and held by the Chinese government. Now, that's a bad breach. The United States federal government has never admitted the breach. They have never told the victims what happened. The only compensation that was given, there was notification for some millions of federal workers that they would be given 1 year of free credit monitoring without a description of what the potential problems were. The trick on that, by the way, is that credit monitoring is the last thing they need. The reason the U.S. intelligence authorities know this was a state actor is because none of the information is turned up on black markets, which is the first thing that hackers that are going to breach your credit or do identity theft are doing. There's some other purpose that the Chinese government has in mind for this personal information. In fact, James Clapper, head of national security, did testify a couple of years ago on this, would not explicitly describe the breach, but he actually congratulated the Chinese on their excellent success, and using the term glass house, infuriated a Senate panel and Senator McCain, the late Senator McCain, by saying it really couldn't be called an attack. And the reason for that position is because the United States is of two minds on cyber warfare. We're on offense, we're on defense, and there's a lot that goes on that, in fact, U.S. government official policy will not say is a crime and is not criminal activity, even when it involves breaches of the sort that we think should be identified, communicated to the customers who are victims, and in many cases remedied by civil and criminal laws. This is something that is very controversial within government policy. I bring that up to give a flavor for, in a context for the idea that the market is not doing its job, the government needs to step in. We have to be a little more fulsome in our analysis of the complexity of the problem. The ability of markets to quickly impose penalties on firms that actually do engage in practices that are not pro-consumer, and the alternative ability for governments to step in and craft rules that are very favorable.
Matthew?
So as one of the victims of that breach, I stand before you with clean hands. When you hear my comments about privacy, in my estimation, one of the reasons that we're all sitting here and we're all here at Pepperdine is because of the incredible growth of the internet industry, the innovation economy, whatever you want to call it. So 30 years ago, we weren't talking about these platforms, these business models. And the reason we've experienced this tremendous innovation, particularly in the United States, is because entrepreneurs, thinkers, dreamers were operating in an environment with fairly light to no regulation. They were allowed to create new business models, they were allowed to use new technologies, and create tremendous wealth and jobs and industry as a result. And because of that lightly regulated space, we have the tech titans that we all talk about, such as Alphabet and Amazon and Apple and others, Facebook, and they all face the rigors of the marketplace. And so when it comes to GDPR and CCPA, I'm extremely skeptical about those laws, those regulations' ability to protect privacy or to level the playing field. And I'm extremely concerned that what those laws tend to do is what most regulations tend to do, particularly when you have large industry players, which is entrench the large players at the expense of the small players. And I can give you an example, having worked for large corporations. In general, large corporations can manage regulatory impositions. They have staff, they have lawyers, they have public policy people, essentially lobbyists on staff, and they could manage that regulation. It becomes what's considered a cost of doing business. For a small innovator, maybe starting in a dorm room, maybe starting in a garage, the barrier to entry is quite high the more you regulate the space. And so the question that I always put to people that are talking about this is, where do you want that trade to be? Do you want to have the next version of Amazon? Do you want to have the next version of Apple? Or do you just want to have Amazon and Apple for the next 30 or 40 years because they're the only ones that can manage this regulatory regime? One might think about the automobile industry. Obviously, at the beginning of the automobile industry, the regulatory footprint of the government on the auto industry was fairly light. And it grew and grew and grew over time to the point where for about 30 to 40 years, when people would talk about the automobile industry in the US, which at one point was the leader in the automobile industry and no longer is, people would talk about the big three, because there were only three. It was almost impossible for an entrepreneurial, innovative company to enter that space, compete, and to compete on an equal footing with what was then GM, Chrysler, and Ford. And so my opening salvo is, I would ask that we think very carefully about regulating a space that's generated such tremendous growth, tremendous innovation, tremendous opportunity for the country, and we do so with a very light hand. And we also have to think very carefully about what do we mean when we talk about privacy, because everyone's got a slightly different view of what privacy is. And one quick example. So the Europeans, my European colleagues and friends often say Americans have no appreciation for privacy, which I know is false. But they point to GDPR and other values they hold very dear. And I, having lived in Europe for a couple of years, am reminded of the fact that the first village I moved to in Europe, one of the first acts I had to do within 72 hours of arriving there was go to the police department and register my name and all my personal details and all the details of my family. And if I moved a mile to the next village, I'd have to register at that police department. So I think when we talk about these terms of privacy, we need to be very careful about what we mean, what privacy is, and also what is our ability to actually defend privacy versus the benefits we're getting by giving up a little privacy.
Okay, so first, thanks for having me out here. Interesting, fun, timely, important, and hard topic. I actually want to start by talking a bit about Qualcomm and CDMA, which has nothing to do with this panel, but I'm going to tie it in. One of my favorite stories, for those who are not familiar with it, if you Google Qualcomm CDMA demonstration, you'll quickly find a video of talking about this, I'm sure. The first live public demonstration of the CDMA technology. It is an incredible story of the challenges of bringing a new technology to market. The entire system basically fell apart. It couldn't get a GPS sync signal that it used for timing during the demonstration, or in the prep for the demonstration. So they had to stretch out the intro remarks for like 45 minutes while the engineers were back in the van trying to resync with the GPS satellites, and they managed to pull it off. It's one of the greatest stories, I think, in the tech industry out there, and you should go watch it.
What year?
88, I think. One of the comments that we heard in the rule of law discussion, I want to build on for my opening remarks for this panel. The GDPR is a European law. It applies to American companies that do business in Europe. It potentially applies to American citizens working, doing business with European firms. It's a European law that affects the whole world. The CCPA is a California law. It is a California law that affects every business in the United States that touches the state of California above a fairly modest size. These are both laws that are very difficult to understand and comply with in an interconnected world. We have the California privacy statute. We could very easily end up with 4, 5, 6, 50 other state privacy statutes, all imposing obligations, compliance requirements on companies operating throughout the country. This very quickly becomes a regulatory thicket and quagmire, each state, each country, each region of the world imposing its own views on others. This is exceptionally difficult for any form of innovation or a startup environment. Matthew has already commented on some of these issues, and I'm sure we will get into them a bit more. What's going on with these statutes? Privacy means very different things to different people. So again, building on Matthew's final remarks, there's a huge difference between concerns about my medical information and my banking information. Those are very different from biometric information about me, very different from information about what posts I share, or things that I tweet, or posts that I like, or who my friends are, or what websites I visit. These are all vastly different things, yet we are sweeping them all up into this concept of privacy, and in these statutes, we're treating them with a very, very broad brush. That's one exceptionally difficult problem with these statutes, and a challenge that we need to face. More generally, what's going on with these statutes? Why do we have them? Why do we care about privacy? I would say my greatest concern with these statutes is the concerns that they're responding to have nothing to do with privacy. They're not concerns about, I don't like Facebook having my information. Rather, they're about a generalized loss of control, or feeling of a loss of control that citizens have in the modern era. And we're striking back against companies that we don't understand what they're doing with their information, how they're collecting it, how they're using it. And even if these statutes are incredibly effective, I expect that this generalized concern of lack of control, loss of autonomy, will still continue to exist. So we're going to be responding to the wrong problem, and in so doing, hampering our innovative economy and ending up 10, 15 years from now still having the same set of concerns. The last thing I want to say, these companies, the reason that we're having this discussion is Facebook has just made such a mess on the PR side for themselves. The entire industry has had problem after problem after problem. They need to hire some better PR people, gotta say. I am generally speaking on these, speaking and writing on these issues, I'm one of those people saying, yeah, I don't like the GDPR, I don't like the CCPA, we don't need federal privacy regulation, we have good basic tools that are great. And with friends like Facebook trying to defend that sort of position, it's really hard because at some point, regulation is the backstop for when the market pisses enough people off. And yeah, the market has managed to piss enough people off that regulation is inevitable. So that leaves us, I think, in an uncomfortable place for how we're going to approach these issues.
Thanks. I'm Chris Riley from Mozilla. Thanks for having me here as well. Thanks for setting me up so well, Gus. You set up a lot of good things there, and the point about regulation being inevitable is one I'm fond of in contexts like this. So I'm here on both the virtual and, in fact, actual left flank of this conversation to be the voice of Mozilla, the company that's quite supportive of having greater privacy regulations. We've supported the GDPR in Europe, we supported the California Privacy Bill, and we're now actively working on federal privacy legislation across the United States. We do this because we try to lead the tech industry in privacy. We practice data minimization before it was cool. We try to do lots of good things with how we handle data to show the industry how data can be used to good business benefit, but in ways that enable users to feel more control, to get to that underlying lack of control problem that Gus mentioned, which I do think is a very real problem here. I think that it's clear to any observer that the honeymoon with the tech industry is over. For a long time, there was very little detailed scrutiny of what the tech industry did with data, what kinds of practices it ran, because it was generating just so much economic value for this country. The rest of the world didn't have that same period because so much of that economic revenue was to the US. And so Europeans, Indians, Kenyans, Latin America have always been more skeptical of tech industry practices than we have been in the US. But the tech clash over the past couple of years has really helped the US catch up in its skepticism and concern over what technology companies are doing. As people learn more and more about what's happening to their data in these systems, that feeds this feeling of lack of control in a way that properly designed regulation actually can help address. I was going to make a big deal of this, but you kind of already took my thunder out from under me. I do believe greater privacy regulation in the US is a matter of not if, but when, and what, and how do we design it in such a way to try to not undermine innovation that we care about and the economic growth, but yet establish a baseline that people want. I do think more awareness is needed across industry, not just in big companies, of the sensitivities and the harms that can result from how you handle users and user data. So I'm thinking of a story from Mike Masnick on Twitter a few days ago. He went around, I think it was CES. He was walking around and looking at all these technology vendors of tools and apps that were designing and targeting their software and their services to kids. And he asked them if they'd ever heard of COPPA, the Child Online Protection Privacy Act, or some acronym much along those lines. And he got blank stares. That worries me. I think that we need to figure out how to be more thoughtful and more understanding of data and of the importance of protecting it. And I feel the same way about federal baseline privacy legislation. I'm worried about the future of technology without effective, enforceable baseline privacy regulations. There's still plenty of room for sector-specific laws on top of that, like HIPAA and others. But without having that baseline privacy legislation, without getting the industry as a whole to be more thoughtful, I'm worried about what will happen to Americans. I'm worried about what will happen to trust in our internet economy. And I'm worried about how separate we will become from Europe, from India, from the rest of the world that has already gotten such a big head start on us.
So Chris, just following up as an advocate of federal privacy legislation and more regulation over privacy issues in general, what kind of effect do you think that has on innovation? A number of the other panelists have talked about the potential negative effects, and if it does have a negative effect, do you think it matters?
I think that you have to look as well at how it creates opportunities and incentives to innovate in ways that are pro-privacy. The California Privacy Bill has a very specific section for this, trying to incentivize the creation of a business model for privacy protection. So it has all of this stuff in it about empowering users to make effective choices, but an explicit setup to delegate your choices to another company. So I think that if it does come into force and is not amended in a significant way or preempted by federal law, we will see innovation in how you can help users ensure and realize their privacy experiences online. And of course, I have to give a shout out to Fast Company, which named Mozilla among its 50 most innovative companies for 2019, and number 3 on the security chart.
That sounds like it's a shout out to yourself.
It was a shout out to myself, but via Fast Company, let's say. In part because of the work that we've tried to do at innovating in ways that help users realize their privacy goals in an effective way. I do think that there's one point of sympathy that I want to sound here. Privacy is a very individual, very cultural, very different kind of thing. Not everyone will choose to express their privacy preferences in the same way, and I think it's very important for regulation to acknowledge and be built around that, be built around the idea of giving users control over their experience. And if users want to have their data be able to be used for all of these purposes, that needs to be part of this ecosystem as well. So I really want to see privacy become a pro-innovation policy and regulation by creating more options, more choices, and more different kinds of business models, not viewed so narrowly as to just say it just takes away the things that we have today. Because I think if it's designed well, it doesn't need to do that.
If I may offer a couple of thoughts as well. First, on that last point, I want to echo it wholeheartedly. More business models, more consumer-facing options, I think, are great. I think we might be jumping the gun a little bit, for instance, on a transition to or an addition of subscription-based options for a lot of services. Over the last several years, we've been seeing more pay-to-use sorts of services coming online, and it's been a slow, high transaction cost environment getting consumers comfortable with these approaches to consuming services online. 2 issues that I don't think have been mentioned yet on the innovation front. First, we need to recognize, acknowledge that many companies use information that they gather from their users for innovative purposes. And very frequently, you don't know what you're going to be innovating 5 years down the road until you come up with the idea, and you might not come up with the idea if you don't have that information. So to the extent that regulation curtails the collection of data, you can only collect data for specific uses, or you can only collect data with clear consent to use it in specific ways, that can dramatically hamper some types of innovation. Another really thorny issue in this area is, what is information? Who owns the actual information? So if Facebook creates a service that didn't exist before and users engage with that service, is the fact that a user is engaging with that service a fact about the user that the user owns, or is that a fact about Facebook? Facebook owns the fact that, hey, my service is being used by such and such a user, and in fact, the user wouldn't have been able to engage, create that new piece of information, but for Facebook having invaded that platform. This is, putting my economist hat on, this is a joint production problem, and this industry is rife with complex joint production problems, and understanding ownership and control issues in a joint production environment is really challenging. And if we're focusing solely on the user side of the equation, we are setting ourselves up for really difficult questions down the road.
So if you think about some of the everyday services that we use nowadays, I'm going to turn to Matthew on this, because your concern was that there would be an impact on innovation. So the Airbnbs of the world, the Ubers of the world, what do you think would happen if companies like that were required to first overcome the hurdles of GDPR and CCPA before launch? Do you think those companies would make it? If not, why?
I think they're less likely to make it. So I take some issue with Chris's point that more regulation creates more opportunities for more business models. I mean, if that were the case, then boy, why don't we lay regulation across every industry and watch the business models blossom? I mean, I know that's not exactly what you're saying, but that seems to be what I drew from your comment, in that more privacy regulation will create more opportunities for more business models. I think that's true if you're a law firm. I think it's true if you're a privacy consultant advising big businesses about how to negotiate these regulations. I think it's true if you're a lobby shop on Capitol Hill trying to figure out, how do I get my client through this next round of regulatory scrutiny? I'm not interested in creating more business opportunities, despite it, it would be in my self-interest for lawyers and lobbyists and consultants. I'm interested in creating more Airbnbs. My big concern is, particularly for small businesses, there are certain areas that small businesses just don't want to touch because they don't have the budget to hire lawyers and to hire consultants. And so I'm not really worried about Airbnb or Google or anything that's truly established at this point, but what I am worried about are the new businesses we'll never see. The new businesses that will pop up in a place that's got a lighter hand in terms of regulation. So right now, if I was advising someone that wanted to do a tech startup or wanted to create a business model involving data, I would say, for goodness sake, don't do it in Europe, don't do it in California, and I question, with the direction of travel, whether you want to do it in the US at all. A lot of these businesses are now popping up in places like Singapore because it's viewed as a lighter regulatory state where you can innovate and take chances and take risks and let the market respond to what you're doing and tell you if you're being successful or not. I mean, the other thing I note is while Facebook has certainly done itself no favors over the last 18 months, I haven't seen scores of people deleting their accounts. So as much as people might be annoyed about Facebook's, using their data in unexpected ways, people aren't so upset that they're not posting family photos or that they're deleting their accounts or that they're walking away from Twitter or any of these platforms. Everyone has a choice to do this, but clearly the market's view is this trade I'm making, some of my personal data, in exchange for free or heavily subsidized services is a pretty good trade. I mean, does anyone here want to pay for their Facebook account or their email account or their LinkedIn account? I've never had anyone say, boy, if I could get more privacy, I'd pay a monthly fee for all these services. And so I think the market has pretty loudly said, we're okay with a certain trade. And I think to the extent that companies abuse that privilege or abuse that trust, they suffer for it, and other companies take advantage of it. This is one of Apple's big selling points, is we really care about your privacy. Use our products and services. So my view, I'd like to let the market sort this out because I think it'll do it in a more efficient way, and I think it'll do it in a way that pleases more people than Senator Wyden.
So is there an argument that the market does in some way sort this out with startups? So for example, I counsel a number of companies, and one of the considerations I have when counseling them is that if you are a startup with less cash, you are less likely to be targeted because you just have fewer users, not deep pockets. So does the market kind of already account for that, such that if you are a new player, you can take some more liberties with various laws and innovate? I'll open that up to anybody.
Well, I think we're slipping into some kind of a context where there's not a market and we're going to create one by having new rules that really incentivize business models that respect privacy. I mean, this game is very well developed so far. The reason that these $100 billion plus platforms exist is because there's this constant dynamic churn of alternative models, and with breaches and some outrage and some mistakes and public relation nightmares and crises and so forth and so on, and $40 billion or $100 billion losses by certain firms. We're already in the game. We're down the road. There have been, business models have been shaped severely by privacy concerns. I mean, there were screw-ups at Google where it lasted just about 30 days where you could, on a simple click, you could allow all your friends to know who your other friends were in terms of your addresses. And Larry Page thought that was just, why would anybody object to sending out an email and every correspondent sees everybody else you've corresponded with? And there was outrage, and Google quickly readjusts that. There was a service called Beacon at Facebook that started taking Facebook users. Previous, better than I about this kind of thing. So they just took things like, Joe was looking for sex toys on Amazon last week, just to try to tell you that your friend Joe forgot to post this on Facebook, and you might be interested to know what he was looking for online. So, that didn't fly too well. And so these adjustments get made. You know, we laugh because you do say, well, you know, who was the engineer who came up with that? Who's the exec that signed off? Good idea. We'll get more information that way. So these adjustments are made. You also have, you know, Tim Cook, the Church of Apple, descending from on high to tell everybody how they take care of your privacy, and they will never do what Facebook does. And I actually caught CNBC. They couldn't help but smirk when that came over, when that first came over. You know, the obvious implication being, of course, Apple won't sell your information. They've taken all your money. There's nothing left. And you know, you really have a different business model there. Some of us like the Apple model for exactly what it's been trashed for, the insular, vertically integrated, high-priced entry fee. And now it looks a little better. These kinds of concepts are shaping themselves all the time, and you know, very subtly adjusted with all kinds of considerations to reflect the constraints of providing value to customers and not outraging them with privacy problems. So the idea that new law is going to improve that is not absurd, and I take Chris's comments to say that transparency can be improved. I don't know if I'm interpreting correctly. I say it so that you can correct me if that's not where you're aiming. But yes, we should see where some transparency can be improved, always having cost benefit in mind, as you know, Don in the opening comments correctly notes. It's not free to do these things. These platforms will be imperfect. Privacy will occasionally be less than we would like. The whole reason we have this ecosystem is because we're waiving certain quality dimensions. And with all due respect to Qualcomm, the only reason we have these is because regulators allowed 5 nines reliability over carrier class telecommunications to be waived as a requirement for public switch networks. That is to say, when you talk on a cell phone, you accept that it's a different quality phone call than a fixed line connection. Now that may seem like a trivial point. You're all used to somebody saying, I'm on my cell, I'm in a bad spot, I'll call you later. Or if you do a radio interview, make sure you get on a fixed line for this call. That's just the way these products develop. We don't consider this as an inferior product because the quality is different than some other quality. In fact, the lower quality, combined with the additional benefits of mobility, is now dominating fixed lines. I don't have to explain that to any audience. So all through the economy, by the way, agricultural markets are routinely cartelized on quality standards where we don't allow quote unquote lower quality products to compete. And it's a they're called marketing orders, but there's restrictions of output and lower consumer welfare because we say the standards have to be higher. If the standards always have to be higher in privacy or anything else, you're going to give up something. Matt's talking about the innovation, the dynamic elements of that, but you're also giving up a lot of consumer choice where consumers might like to have something that is for, you know, priced by Facebook and not by Apple, and is readily available because of that low price, that low entry fee, to hundreds of millions of other customers who are trading information and paying for their access by allowing others to productively use that information. So just ratcheting, yeah, it can create new business models. Ratcheting up those protections in a single entry bookkeeping world is good, but it's a double entry world. And so you're going to be giving up a cost there that really has to be reflected if you protect consumers. Consumers want to be able to use the whole raft of choice, whether it's a fixed line choice versus a mobile choice, or in this case, more privacy versus a little less privacy.
I'd love to riff on that if I could, if you don't mind me just continuing. I mean, I do think transparency is a big component of this, but the biggest thought that I want to share after what Gus and Tom in particular said is I feel sort of simultaneously like the outcome that privacy advocates like myself want from legislation. We are both closer to it and at the same time further away from it in the world that we have today than I think is being realized. So let me explain that. Looking at the principles about what we want out of federal privacy legislation in particular, we want rights for users like access to data about you, ability to request deletion, clear rules on data handlers and processors, purposeful collection of personal data, make sure that you're collecting it for a purpose, granular and revocable consent over what information is collected about you and how it is used, limits on secondary use, and effective enforcement authority. I actually don't think that's that radical a change from the way the market is heading. I think Tom's point is right that we already see limits to some of the most egregious practices that come up naturally. We already see things like, I have an Android phone, like the amount of information you get over the apps on this phone and what they can do with it and what kinds of things they have access to, a lot of progress has been made in recent years to help users understand that. So on some level, I feel like we're already heading in a good direction. And so some will argue, then why do we need law? I would argue instead, well, law is protecting the growth that we've made and establishing a foundation and a protection for the future. So different ideological points there. At the same time, though, I think we're also further away in how we think about this and why. So I'm fond of saying the original culture of Silicon Valley was a culture of collect all the data, keep it all forever, and figure out how to monetize it later. And that's the cultural shift that we actually want to encourage a movement away from, to be more thoughtful and purposeful in what you collect data for and what you use it for. So back to the market point, I think we're already seeing a lot of pushback from the public when data is used for purposes that surprise users, when it's being used in ways that they don't expect. But there's still some major changes that I think we need to make. And so my favorite illustrative example of this is Facebook and phone numbers. So Facebook collects your phone number for two-factor authentication. Let's say you've been resisting giving Facebook your phone number because you don't want them to know that about you. You don't want them to use that for other purposes, cross-correlate that into other databases of information and so forth. You give it to them for two-factor authentication or security purposes. You give it to them with the expectation that the only thing Facebook will do with that number is if you're trying to log into Facebook from a new computer, they'll send you a text message with a little code like many of us in the room probably have set up for our banking services and others and so forth. Facebook then turned around and used that phone number for marketing and for identification purposes. And people started seeing cross-correlation of behavior based on their phone number and how that was being used. So that kind of secondary use, it feels wrong to me. And it came about almost by an accident because I think that companies weren't thinking about that. And they have this record of a person that says, oh, what's the person's phone number? They put it in. You take it in for one purpose, you slot that phone number into the person's record, and then everything else that's been built on how do you use a person's phone number starts to trigger it and start to kick in. So it's sort of a relatively minor change, but it's also sort of a relatively major change to create and put a person in power to say, no, use my phone number for only one purpose. So I'm sure I set up a lot of other things with that. So
well, I'd like to riff on this and continue to respond to the question as well. The question of how to advise startups in this area, I think, is really hard. And I'm going to say something possibly surprising, which is the area we need perhaps the most regulation or at least awareness and thinking about these concerns is in the startup environment. It's not the Facebooks, it's the folks in the garage. The reason for this is every startup aspires to be the monopolist. Google one day was a startup. Facebook one day was a startup. And there was a period, and I still hear stories of this even today, when venture capitalists, if they heard that a startup was thinking not about privacy, but about security concerns in their products early on, they'd back out. They didn't want companies to be wasting time and money incorporating security features into a product that probably was going to fail. So they thought the thinking was, don't do this now. If you blow up, if you're $1 billion company, then we can put all this stuff back in. Well, the problem is refactoring is hard. It's really hard to add security. It's really hard to add privacy features into a product once it is a live product, just as a technical matter, not even as a user expectation and experience matter. So the story about COPPA is a really important one. We want startups, we want the small companies to be thinking, okay, if I'm really successful, do I want to be Mark Zuckerberg being grilled by Congress? Or do I want to be thinking about this stuff, hopefully not in a regulated from my perspective way, but do I want to be recognizing the mines that I'm laying for myself in the future at the ground floor? Another concept that I've been borrowing and starting to throw around in these discussions, I think a lot of folks are familiar with the idea of the uncanny valley. That if a machine is clearly a machine, we're comfortable with it. If it's a perfect android that is indistinguishable from another person, we're comfortable with it. But if it's kind of obviously trying to be human-like, but also not quite, it's really creepy. I think privacy has an uncanny valley problem. I think that targeted ads, user preferences that are tracking you and making products better, more convenient, doing predictive stuff for you, when it works, it is awesome. And it's seamless, and we think it's great. When the products aren't doing anything with this information, it's great. We're not worried about it. But when we're getting the ads that are clearly trying to be targeted and they're misfiring, or it's something that's being targeted that really shouldn't be targeted, we're in an uncanny valley sort of situation. And I think an unrecognized part of the discussion is to what extent is the market adapting to this, responding to this? Is the technology continuing to improve to get us out of the uncanny valley? Either by saying, okay, we can get out on the side that lets us use these technologies, or there's no way to get out of it, so we need to stop using these technologies. A lot of what's driving the privacy discussion, I think, isn't that people are concerned that their information is being used. It's that they are uncomfortable with the perception of how it's being used, and that's largely an uncanniness dynamic.
So, panelists, you've talked a lot about giving consumers choice and how that seems to be notice and transparency, and choice seem to be a motivating factor behind these statutes. So if we talk about a lot of different services in the US, a lot of it is free because of advertising. So, you know, I have small kids, I go on Amazon, I look up Elmo, and suddenly Elmo is basically creepily following me throughout the rest of the internet. But what if we decide to have a different type of system? For example, if Facebook was free, if you are fine with being tracked for advertising purposes, but yet you offer an alternative where Facebook is $10 a month on a subscription model. What do you think the effects are of that in terms of potentially having discriminatory effects? Chris, I'll start with you.
So I'll wear more of a European hat than an American one for a second and just say there is something fundamentally anathema to many people about having to pay for privacy. In Europe in particular, privacy is a fundamental right and you should never have to pay for it. So I think that we need to be thinking about options to users in a broader lens than just Facebook as we have it now, or a pro-privacy Facebook that's for money. I think there is a lot more creativity and diversity that could go into a pro-privacy business model than just that.
Matthew, do you have any thoughts?
I fundamentally disagree with Chris. You know, I find it odd that everyone wants all the benefits and all the goodies that these platforms provide, but nobody wants to provide any information about themselves, which is the lifeblood of these platforms. In other words, I want my free LinkedIn, I want my free Facebook, I want my free YouTube, I want to be able to see every episode of Gilligan's Island. I want free social networks, I want free Twitter. I don't want to give any information about myself away. So, you know, what are these companies to do? How do they have a revenue stream? How do they have a business model? If the answer is, well, the business model can't be advertising anymore, then we destroy a lot of tremendous economic value that's already been ginned up. And as Tom said, we're already pretty far down the track. And so, you know, I'm not troubled. If you want to have an advertising-free experience, then you can pay for that. Or if you don't want to be bombarded with ads and you don't want to pay for it, you can choose not to participate in that platform. I mean, I believe YouTube offers opportunities to pay and be free of looking at the 4-second ad before that, you know, clip of someone falling down a flight of stairs runs. or you can choose not to watch the video on YouTube. I mean, you know, consumers have choices, and the companies are responding to those choices all the time. I just don't see how introducing very rigid regulatory regimes is going to advance the cause and make it a more free-flowing environment with greater privacy protections, because I think the market is already pretty responsive to consumer complaints. I mean, that's why Facebook is tripping all over itself constantly to change things, adjust things, because people get upset and they respond. And so I'd rather see it play out that way than regulations which wind up being on the books for 20, 30, 40 years and don't change, and you know, stifles a lot of innovation, and not just innovation, but competition. I think competition is really important. So if Alphabet and Facebook have these moats around them and they're not challenged, they're not going to innovate. So, you know, I'm not troubled by setting up tiered systems where you pay for the kinds of service you want.
Can I respond very briefly to that? I think it's extremely misleading to confuse privacy and advertising. There are different models of advertising that are not built on the collection and the building of behavioral profiles of individuals and actions. I'm fully comfortable with having a pay for an ad-free experience world, but that's different from having a advertising supported but friendlier on privacy business model. So to conflate and confuse those two is not how the advertising world is looking at the situation today, and not how we should be looking at it when we're talking about privacy law. It's not saying get rid of all of the advertising by any stretch of the imagination.
Well, yeah, I was recently writing something on the on Senator Wyden's proposed legislation, and I went to read his essay posted on NBC's website. And as I was reading about the outrage of using information without the express consent of consumers, I noticed that the ads adjacent to Senator Wyden's essay were telling me about automobiles that I had recently scanned on the internet and popping up with real estate ads in some of my favorite real estate markets. And I smiled to myself that instead of posting this on his website, advertising free, Wyden wanted to take the advantages of the commercial platform provided by NBC using my personal information, which I certainly don't recall giving to NBC, but maybe buried down there in some contractual daisy chain. And in fact, people are, including Senator Wyden, taking advantage in so many complex and multitudinous ways that we can't even create the chart for the system we have. Now that does scare some people, and there can be violations of privacy that are problematic. We want to, and would reasonably want to fix. But the idea that there are tremendous advantages that are being generated here seems to be lost in the mix. You go back to the beginning of the Google search algorithm. Search was a commodity in the mid to late 1990s. It was thought to be a problem that had been solved. It didn't work that well, as we now know, but it was just a keyword search, and that was fine. And you know, these two young punkaloos that who never finished school, by the way, in the computer science department at Stanford had an algorithm. They had this page rank, and then they had this crawler, and they put them together, and they started doing this stuff, and they had to think about a business model to pay for it. They were there was an entrepreneur who desperately tried to talk Page and Brin into intention-based advertising, using the private information from search users to sell them ads. And that was evil. So in 98, 99, you read their 1998 article on this where they explicitly say you can't do the search engine on a advertising supported for-profit basis. It has to be nested in a nonprofit like a university. And Gross was the name of the guy who actually ended up selling him this model a few years later, and he ended up on an intellectual property dispute getting about $250 million worth of stock when the company went public. But he had intention-based advertising worked out. He finally sold it to the people who explicitly said this would be evil, and then switched on it. They saw it as a violation of privacy, a corporate play to create a commercial platform at the expense of the rights of the users, and they were wrong. This has been a tremendously important breakthrough for society. Of course, Page and Brin now see the error of their ways, and they have, what, $30 billion of capital value urging them on. 30 billion good reasons to understand that they were wrong, each, plus or minus, depending upon the market today. But that is the force of the marketplace. That is the expression of consumer demand. And the margins of this are important, but the inframarginal explosion that we're dealing with here, this real transformation of information markets, is enormously productive. And we have to understand how that comes in. So when Matt talks about the next Google, the next breakthrough, we do have to be very careful that dealing with the increment does not destroy the process of disruptive technology innovation that has been extremely powerful. And last thing I'll say is I really don't understand the idea that people won't or can't pay for privacy, particularly Europeans, where I learned the privacy was costly when it said private bath. Now you'll think that my mind runs in these directions generally, but as soon as you said the Europeans don't want to pay for privacy, I thought, well, if you get a private bathroom, you pay for that, right? That's all about privacy. And it's completely on a continuum with every other product, essentially. More privacy is more costly. Real estate, privacy is costly. It's everywhere. And this is the latest generation, and it presents challenges, but I don't think it's sui generis.
I want to quickly add something. I don't think we've responded really to Anna's question about discrimination and advantaging or disadvantaging marginalized communities. And this is an important element of the discussion that I think we need to highlight, because it's one of the hardest and from a policy perspective, most important things to recognize. And I don't know that there are good answers here. One of the great things about the current internet is you don't need to pay in order to use most services, which means if you don't have much money, you can use most services, which is incredible. Another important thing about internet business models, and this isn't internet business models, this is business models generally, it's hard to have a blended business model. That is to say, for both technological reasons, it would be hard to design, and also from a consumer perspective, it would be hard to have a Facebook where you could either pay for service, you could pay for service and have some information collected, you could pay nothing and have all of your information collected. Maybe it could be done, maybe it would be successful. More likely the successful platforms are going to have a single, simple revenue model. If we transition to a payment-based one, or if through regulation, legislation, we prevent companies from monetizing consumer information, or we make it so complicated to monetize information through regulation, companies just say, okay, I'm not going to bother collecting information, I'm going to go to a subscription model instead. There are a lot of marginalized communities that might not have access to this information. There are, I think, potentially problematic, also very normal paternalistic overtones to a fair amount of discussion about marginalized communities getting access by exchanging their information, their private information, by marginalized communities. Sometimes I'm referring to communities that have information they might not want to be made public or shared about their characteristics. Gender, sexual orientation sort of concerns that you don't want these internet giants to be gobbling up, or just the economically disadvantaged lower income individuals who can't afford to pay for this information. My general view, and I think there's a lot of studies to back this up, is that marginalized communities tend to understand these issues a lot better than folks who are not members of those communities. Lower income individuals tend to be much savvier when it comes to deciding how and where to spend their relatively few dollars than the people in this room, on this panel, sitting in the halls of Congress, either give them credit for or themselves are. So I think we need to be thinking and understanding these concerns, and we also need to be thinking and understanding about how well we understand these concerns.
I think we're running a little low on time, so does anyone have any questions at all? Yes. There are microphones too, if you want to.
Yeah, I think this is a question for Mr. Riley. Can you, from the small to medium size firm perspective, so like 50 million to 100 million, so still covered by the California statute, but not widening as much as some of the major players in the area, why is it preferable to have regulation versus, say, the market correction that Professor Hurwitz was mentioning? Yeah. Does that make sense?
Well, clarify for me, from the perspective of these companies, do you mean imagine that I am at one of these companies and I say that it's preferable?
Yeah, would it be preferable? Or you can also take a societal perspective, but
So, I mean, I won't try to put myself into the perspective of a company like that. I think about this much more at the societal perspective level. I mean, the Mozilla mission is, we're a mission-driven organization, and we set the policies and the positions we do based on what we believe will make the internet better, first and foremost, more than anything else. And so I do believe that having baseline regulation on privacy will make the internet better than strictly letting market forces do that. And I believe that that's true when federal privacy regulation is applied not just to the largest companies, but also to mid-sized companies, and I would say to startups. Some of that could come from the arguments that some of my fellow panelists made, Gus in particular, that it's hard to refactor privacy in. You have to think about how you design your data collection and your data policies and so forth earlier on in your business cycle, not just bolt them back on after the fact or it doesn't work. But Mozilla is also, in particular, a big believer that being lean about your data reduces your risk as a company. So now that doesn't directly answer your question, because we try to do direct advocacy. We have a toolkit called a Lean Data Principles Toolkit. We directly socialize this with smaller and mid-sized companies to try to help teach them what we've learned about how to be more purposeful and more limited with data collection and data processing. So that's not an answer to market forces versus regulation. It's more a statement that we believe this is an unequivocal good and a good thing for businesses of all sizes to be doing. Frankly, we're supportive of regulation because we're not seeing that happen yet, right? We don't see the market delivering on the kinds of purposeful and limited collection and use of data that we believe the technology industry should offer. We don't see the kinds of granular and revocable consent that we call for and support in legislation being offered by the market today. And so we'd like to help shape a better internet of the future, and we see regulation as a very effective way to do that.
Yes.
So my question is mostly for Matthew, but also to anybody else who has insight on it. I think a lot of people argue that consumers don't really understand exactly what they're giving up when they give their privacy or their data over, So I think some argue that the regulations and laws are trying to equalize that transaction to try to educate consumers what they're giving up, or at least give them more bargaining power, I guess. So how do you respond to the idea that the regulation is necessary to do that, and that consumers maybe don't realize the value of what they're giving up for these services that they're getting?
jump in on a response if you want.
Oh, I'm happy to take a crack at it. But,
Okay.
I think at this stage of the game, I think consumers have a pretty good understanding of what they're giving away. And so my running assumption on any of these platforms is if I'm putting information out there and it can be attached to my name, that company is trying to figure out a way to monetize it. Now, could companies be better at making the disclosures more detailed or putting it into more layman's language? Of course they can. And perhaps the companies that figure out how to set up those feature sets in terms of making the consumer aware of exactly what they're trading away will be advantaged in the marketplace. I'd just much rather let the marketplace sort those issues out or let consumers choose the companies they think are most vigilant around their privacy than having congressmen in Capitol Hill that barely understand these technologies try and regulate them. I feel much more comfortable with the marketplace responding to the needs of consumers than regulators. And again, I go back to the point I made earlier. We don't see masses of people fleeing these platforms because they're that outraged about the privacy practices. Now, privacy advocates are really outraged about the privacy practices, but I think there's a significant gap between where the privacy advocates are and their response to these issues and where the marketplace is. I think if the marketplace was upset about it as the privacy advocates, we would have had regulation long ago, and we would have had many more companies providing services that are more in line with what Chris might think are best practices. So, I think at this stage of the game, consumers get the idea that, when I give away my information and I'm getting this free service, that's the trade that's being made. I don't know, Gus, if you want to chime in.
So, in the background of your question is one of my least favorite arguments that folks very frequently make when we're talking about this stuff, which is no one reads these privacy policies, no one reads the contracts, so they're totally ineffective. If that's your form of transparency or disclosure, it's garbage. My response to that is all hail the marginal user, which is to say we don't need everyone reading these contracts. We don't need everyone reading these agreements. We just need one person reading them, or we just need a small cohort of folks reading and understanding them. In all markets, the marginal user protects the inframarginal users or customers. And this is a market where every change to a privacy policy is scrutinized by a entire industry of crazy consumer advocates like Chris. So if there are problematic things going into these disclosures, problematic policies, they're not going to be hidden for long. They're going to be front page New York Times, FTC is opening an investigation because such and such a consumer group saw this change and is mad as hell and not going to take it anymore. So to the extent that underlying your question is a concern about, well, are these disclosures really effective? Yeah, they are.
If I could very briefly add to that, I do think that we've sort of surfaced one of the most fundamental areas of disagreement because I don't believe that consumers have enough understanding. I wish they all listened to Mozilla and how we interpret and try to be that intermediary, but we don't have that kind of visibility or awareness. And I also don't believe, at the risk of overly segueing into what I think is the next panel, I don't believe that competitive forces work well enough to allow for the rapid creation of new competitors and new business models in the sticky markets and technology bases that we have today. And I can completely understand intellectually why people who believe differently than I do about customers' level of awareness and the effectiveness of competition in the technology sector come out in a different place than I do on the need for regulation.
Yeah, so, well, I was going to say that there's, this nirvana fallacy that there's some pristine state of the world and we're violating it, and, people sign, click-throughs all the time. Get me access to the platform. Why are all these click-throughs coming? And let's get out of here. And it's thought to be consumers are ill-informed, and they need to be better informed, because in some kind of perfectly functioning market, they're going to know everything there is to know. It's not true. You walk into Chipotle, there are all kinds of agreements and contracts and all kinds of precedential law that governs that relationship with Chipotle. I use this example because it was given wrong at a law conference I was at some time back. And it said, well, at Chipotle, you don't have any of this click-through stuff. Yeah, but you got it's just as complicated a relationship that the customer doesn't care about, doesn't want to take the time to invest in. It's really, it's a market transaction. If we don't like it, we won't come back. You have every time you buy ibuprofen, okay, you get that little thing out of the box that you throw away. Well, read it sometime. It's got chemical compound reactions on there. It's got language from Supreme Court cases. It's got extreme information on there, and that's just the tip of the iceberg. They tell you to go to the website to get the real story. Nobody reads that stuff. Okay, we have other mechanisms for figuring out costs and benefits, and that's efficient. We don't have complete contracts. We know that incomplete contracts are efficient. So there's no nirvana state here. And it really is a cost-benefit world. So if we have time, I'd like to know, GDPR, is it working? Do we like the direction it's going? I've noticed two effects. I have more click-throughs now, and the big firms seem to have no problem with this at all, the big platforms. And I do know that there are a lot of missing European access sites. If you go to Europe, you can't get a lot of American sites. About 1,000 American sites have taken down their European operations because they don't want to have the expense. They don't have large audiences, and it's just too costly. So we see that there is an innovation cost, a competition cost to that kind of extra overhead. The question is it worth it? Is there a benefit that's coming through GDPR that we can see? I don't honestly know the answer to that. So if anybody wants to comment on that, we have time. I'd love to hear.
I think we're running a little low on time. I don't want to completely roll over our lunch.
Okay, we'll click through.
Right, we'll click through. All of us are available at lunch if you'd like to chat about any of these topics with us. So I'd like to thank our panelists and Pepperdine for having us. Thank you.